Welcome back to Law and Society. It's where legal and social issues come together with Andrew Stevenson. And by the way, if you hear anything today and you want to hear this, you can go to our website or Andrew's. We're going to get this posted. There's about 10 or 11 shows posted online.
Yep.
And you can hear all these great topics. But also, if you find yourself hearing those magic words, you have the right to remain silent. If you feel the bracelets go around you, say, I want my attorney, and then StevensonCriminalDefense.com will get you hooked up.
Great.
Does that sound okay?
That sounds wonderful.
All right. In part 2, we're going to talk about what makes a deal, quote, good, unquote.
Yes.
So how do you know when you're getting a good deal?
I usually explain this in terms of cars. People understand this. Most people want a good deal on a car. They ride to their friends. They got a great deal on this car. And there's kind of 4 situations that what they mean. For example, if they paid less for the exact same car than they could have gotten it elsewhere, they think they got a good deal. If they paid less for the exact same car as their friend did, they think that they got a good deal. If they paid less than the car is worth, or if they found the right car for them at the right price, they think they got a good deal. The first 2 of these don't apply in the criminal justice system, meaning that no 2 cases are exactly the same. The facts are different in every case. The judges are different. The county's different. The prosecutor's different. And then the big wild card is the defense attorney's different. But so getting the exact same deal as compared to where you would have gotten elsewhere, you can never measure.
So there is no standard deal. The prosecutor doesn't have a list of, A, B, and C.
They tend to have tendencies that they go to.
Right.
But that you can't evaluate a deal in terms of other people. I've had people say to me, well, my buddy got charged with theft and his case was dropped.
Right.
Okay, well, there's maybe a reason why. For example, the complaining witness didn't want to prosecute, or the video from Walmart got lost, or there could be a lot of other explanations.
The video was blurry and it was,
you couldn't tell. Yes, things like that. So, I've gotten extraordinary deals in all types of cases, but every case has to be evaluated on its own terms and merits.
Does emotion come into it at all?
Sometimes prosecutors they assess the value of their case emotionally. I feel that this person deserves this punishment, regardless of whether or not they have enough evidence to convict them, or whether or not that's what the law provides. They say, I feel this way, and so then they tend to push for that. So one of the 2 ways to evaluate whether or not a deal is actually good is in terms of, did I get the car for less than it's worth? And what that essentially means is, did you resolve the case better than an outcome would have been at trial? And that is probably the most difficult thing for defense attorneys to do, particularly early on in their career, is evaluate what is really likely going to happen at trial.
And going in, there's this trial tax we talked about.
There's a trial tax.
It's an unspoken thing, but
and you don't know
there.
what juries are going to do.
Yeah.
And that's where the experience of the attorney comes into play. And then the second issue really is, did I get the right deal for me given my circumstances, given my family, my job, my future, my career? And what is a good deal for one person may not be a good deal for another. Someone may lose their job if they're convicted of this charge, and another person may lose their job if they have to miss a week because they go to jail. But it doesn't matter what they plead to. So one of the key things when people ask me, how do I know if I got a good deal? Things that I think are important for people to do, first of which is to make sure you have a full and complete conversation with your attorney.
Okay.
And that is where attorneys, by and large, fail. You need to sit down and have a conversation. 5 minutes at the courthouse is insufficient.
Okay.
You actually have to have a conversation on the phone or in the attorney's office in which you make sure, 1, that they've shared all their information with you. You've seen all the discovery. 2, they've given you their opinion about what will happen, why they feel a trial will result in this way or that way. And 3, you've shared everything with them. There's nothing worse than being in trial and this witness walks in and says something, and you look at your client and go, oh, I meant to tell you about that. That just doesn't go well. And a lot of clients will keep stuff from their attorney because they want the attorney to tell them good news. They want to hear it, but it's best to know that.
And again, that's a lot of, without the experience, sometimes it almost sounds like It's almost like the classic negotiation. Prosecutors start high, defense attorneys start low, and they kind of come together and somewhere in the middle.
Somewhat, yeah. And then finally make sure there's been a full investigation.
Yeah.
That is probably the second biggest weakness in handling criminal cases that I see attorneys make. They simply don't explore everything. They don't challenge everything. And there is not a full investigation. Without knowing all the facts, you really can't make a full and complete decision about how to proceed.
And we're gonna have a great story here, and we're gonna talk about why dismissal is not necessarily a good thing.
Yeah,
we're gonna get to that, but let's talk. We got about a minute till we need to, because I want to give enough time for your story here. But what are some of the keys? Again, if you talk about full investigation, is this on the part of the police?
No,
the
this is independent
or?
investigation.
Okay.
I work with a private investigator.
Okay.
I would say 90% of the cases I handle, we independently investigate. We go to the crime scene. We go talk to witnesses ourselves. So, we look at everything.
So if you're going to trial, you
cannot rely on what the prosecution tells you, period.
Amazing. Okay.
Anyone who does is not doing their job as a defense attorney.
Again, that adds to the cost of the defense.
It adds to the cost, but it's time, it's energy.
But
it's
again,
effort.
if somebody's truly innocent, and again, remember, there are people that get charged with things that they didn't do.
Right.
It does happen once in a while.
Well, most people are charged with either overcharged.
Gotcha. Yeah.
They may have some guilt. It's just a question of what. Mm-hmm. And so, when trying to decide whether or not to take a deal, I went through this with a client, and he was a landlord, and he had gone over. He got a call on I think maybe a Thursday or Friday morning, and had gone over to the tenant's house because the furnace was not working.
Okay.
And he knocked on the door. He went inside. And the first thing you do when you work on a furnace is check the thermostat. Make sure it's not as simple as the batteries are dead in the thermostat.
Right.
So he went in, he checked the thermostat, and then he went to work on the furnace. Now, the furnace was in the basement, and the only way to get into the basement was from the outside of the house. So he went down, and he was in the basement for maybe 15, 20 minutes, checking different things, trying to see if he could get the furnace to kick on. And he couldn't. So he gave up. He went out of the basement, went to his car, got on his phone, and texted his wife, made a few phone calls, and called the furnace repair people. And he was sitting in his car waiting for the furnace guy to show up when the female who was the tenant came running out of the house and ran down the street, and there happened to be a police officer parked on the side of the road. She went banging on his door frenetically and screaming, "Help me, help me," with tears in her eyes and claiming, "I've just been raped, I've just been raped." And the officer said, "What do you mean?" She says, "I've just been raped." And he said, "Well, who was it?" He said, "Well, that guy up there, 3 cars, sitting in his car, raped me." And so they took her back to the police station. They interviewed her. She willingly went and had a rape kit done. She told her story. She was tearful. She was sad. And that night, they came to the landlord's house, and they arrested him, charged him with rape, threw him in jail. At the initial preliminary bond hearing, the family had hired me, and I went and met with the prosecutor briefly, and I said, "Listen, before you go ahead and indict him on rape charges, I think there's some things you should know. You might want to do some more investigation." At which point, he looked at me and said, "We're not doing investigation. We've got the right guy. I've interviewed lots of rape victims in my career, and I can tell you she's not lying, and she was raped, and your guy is a monster." Okay. Sure enough, true to his words, he went ahead and indicted my client about 2 days later on rape and kidnapping charges. Now, the information that I had to share with him was threefold. First of all, that she had been served with an eviction notice about 2 to 3 days prior to him coming over to fix the furnace. Adds a little bit of intrigue. More importantly was that we had his cell phone records.
Right.
Which, given the time from when he arrived, from when he texted his wife and said, "I'm here," to when she reported to the police, we could account for all but 8 minutes of his whereabouts.
Okay.
He was texting on his phone, or he had made a phone call. And third, we had the conversation, we tracked down the furnace guy. And he said, no, when I talked to him, he wasn't out of breath. He wasn't wound up. There wasn't anything unusual about him. He was calling about his furnace. He told me what parts he'd worked out in the furnace. All of this information we provided. And so even after he'd been indicted, I provided that, and the prosecutor was still reluctant to listen. At which point we then started demanding that they do additional DNA testing. In fact, we wanted something called YSTR, which is when they look for male DNA only.
Okay.
And the prosecution was reluctant. So we said, we'll pay for it. We'll get it done. They stonewalled us every chance we could until finally they agreed to have it done. Lo and behold, sure enough.
Not a hint.
Came back. There was male DNA.
Oh, okay.
Wasn't his.
Okay.
It was some other guy's. Now, you'd think that'd be enough, but it wasn't. And the prosecutor basically said, listen, I don't care. Your client could have worn a condom. He could have done other things, which would have not left his semen there. He, I don't know what's going on, but I'm telling you, we're still going to go to trial, and her testimony is going to be so compelling that even though you've got phone records, you've got bias on the part of the witness, that we're still going to convict your client. And I said, okay. So sure enough, as usually the case, about 2 days before the trial, I get a call from the prosecutor, actually about a week before. And he says, listen, here's what. I want to make you a proposal. If your client would agree to a protection order for 5 years, I'll drop the charges.
Meaning stay away from her for 5 years.
Stay away from 5 years. Now, that sounds like a pretty good deal. You're facing the next 20 years in prison, a registered sex offender.
Right.
Yes, there may not be your DNA, but she's going to claim it was the boyfriend's and you wore a condom, right? You've got some issues. I sat down. We spent hours talking about this and evaluating the case, and in the end, we turned that deal down. The day before trial, I get a call from the court which says, hey, guess what? The prosecutor has sent up a dismissal. So we called his bluff.
And
he sent up a dismissal. And you would think my client would be jumping up and down and we'd be ecstatic.
Except he dismissed without prejudice, right?
Yeah. So he tried to. So what happened is I went over to the court and I had to have a hearing before a judge in which I said to the judge, we don't want this case dismissed. And the judge said, why? And I said, because the prosecutor wants to dismiss it without prejudice. Now, what that means is that technically they have a right to refile.
Exactly.
But that wasn't the issue. The issue was that in order to get your case sealed, if your case is dismissed with prejudice, you can get your case sealed instantly.
Right.
If it's dismissed without prejudice, you have to wait until the statute of limitations has run.
Which is
25 years.
Holy crap, yeah.
So my client would have had this rape charge that, although it was dismissed, on his record for 20, he had no chance. So I have actually argued in court to not have rape charges dismissed because it wasn't a good deal.
So how does that judge handle
To his
that?
credit, the judge took the words without prejudice and drew a line through them and put with prejudice and dismissed the case.
This is a great story.
Yeah.
And it just goes to show, take the deal. Well, then the deal is going to hang you for 25
sometimes
years.
you have to evaluate every aspect of a deal before you take it.
Wow. And so, the innocent do get charged sometimes.
They do.
Excellent. Well, we're 13 and a half minutes into this segment. We're over time, but what a great story. See, just bring more stories.
I'll bring more stories next time.
Andrew Stevenson is our attorney at law here, and this is called Law and Society, where legal and social issues come together. Again, StevensonCriminalDefense.com if you'd like more information. Again, if you find yourself hearing those words, you have the right to remain silent. The first thing you say is, I want my lawyer, and then you shut up.
Yep.
Thank you, Andrew. We'll see you next month.
All right, bye-bye.